In 2020, my father passed away, and someone handed me the keys to his house and said, go figure it out. I'm a real estate broker. I've been doing this for over 25 years, and I've sold hundreds of homes, and I still didn't know where to start. That's how confusing the probate process is, even for someone who does this for a living. Now, imagine being a son or daughter who's never dealt with real estate before, who's grieving, who's managing siblings, creditors, and a house that may or may not be in good condition, with zero roadmap and zero guidance. This video is the one I wish someone had handed me in 2020. If you are a personal representative, an executor, or someone who just inherited a parent's home and has no idea what comes next, stay right here. I'm going to walk you through the entire process, step by step, specifically rooted in Utah law. And I'll tell you exactly how to protect yourself and the estate along the way. Everything I share here is for educational purposes only. You should consult a probate attorney for your particular situation. And I'm going to tell you in a few minutes how you can access one with no upfront costs. Also, this video is specifically grounded in Utah law. The general principles apply broadly, but please verify the probate laws in your state because they can vary significantly. Let's start with the basics. The probate is the legal process that happens after someone passes away. The court ensures that the deceased debts are paid, taxes are settled, and their assets, including real estate and property, are transferred to their heirs. In Utah, probate is required when a property is titled solely in the deceased's name. No joint tenant, no living trust, no transfer on death deed, just their name on the deed. You need probate. Now, here's actually some good news. Utah follows something called Uniform Probate Code, which means the system here is designed to be more streamlined than many other states. There are essentially three tracks. Track 1, small estate, affidavit. If the state has personal property valued at $100,000 or less, and this does not include real estate, you may be able to skip probate entirely with a simple notarized affidavit. No court required, but the moment there's a house involved, you're in one of the next two tracks. Track 2, informal probate. This is the most common path for uncontested estates in Utah. It's handled through a probate registrar, and here's what makes this significant. No court hearing is required. The registrar reviews your paperwork and issues your appointment faster, less expensive, and less painful. Track 3, formal probate. Court supervised, required when heirs dispute the will, when there's no valid will, and when conflicts arise or when the estate is particularly complex. More oversight, but also more legal protection for you as the personal representative. And let me say this clearly. The filing fee in Utah for either informal or formal probate, only $375. That's your starting point. All right, let's walk through this step by step. Step 1, don't panic. Get organized. The first thing you need is the will, if one exists. You'll also need multiple certified copies of the death certificate. Every institution you deal with is going to ask for one. Get at least 10 copies. Then gather property deeds, financial statements, and any outstanding debt documentation. Make a list of everything the estate owns and everything it owes. This is your starting inventory. Step 2, determine which track applies to you in your situation. Look at how the property is titled. If it's in a living trust or held jointly, it may transfer automatically without probate. If it's in the deceased's name alone, you need to file. Step 3, file with the district court in the county where the deceased lived or where the property is located. The informal probate with a will, that's Form 1002 ES. Without a will, Form 1001 ES. The filing fee is $375. Step 4, get appointed as personal representative. Once the probate registrar or the court approves your application, you'll receive what's called letters of administration, or if there's a will, letters testamentary. This document is everything. It's your legal authority to act on behalf of the estate, to manage bank accounts, to handle property, to sell assets. Get multiple copies. Every bank, every title company, every institution is going to ask for one. Step 5, notify creditors and beneficiaries. Utah law requires formal notification to known creditors. who then have approximately 60 days to file claims against the estate. This is one of the primary reasons the process takes the time it does. Step 6, protect and manage the estate. Here's where a lot of people drop the ball. As a personal representative, you have a fiduciary duty to protect the estate's value. Keep the property insured, maintain it, document its condition thoroughly, make sure you take videos. The estate is financially responsible for that home. Every month it sits without action is money coming out of the heirs' pockets. Now, I want to stop and address something really quick, because this is the part of the video that might save you some real money. You will hear sometimes from well-meaning attorneys, sometimes from family, sometimes it's just from people who assume they know, that the house cannot be sold until the entire estate is fully settled. That is not accurate, and believing it can be a very expensive mistake. So here's the truth. In Utah's informal probate, the most common track, once you have your letters of administration, you have broad legal authority as the personal representative. That authority includes the ability to sell the real property during the probate process. The sale proceeds do not need to be distributed immediately to the heirs. They are held in the estate escrow account, sometimes called probate escrow, while the remaining estate matters are resolved. Creditor claims are paid, taxes are settled, then distributions are made, and sometimes the home has to be sold. If the estate carries outstanding debts, a remaining mortgage, medical bills, credit card balances, isn't enough liquid cash to cover them, the property may need to be sold to satisfy those obligations. The court can require that. Do not let anyone tell you that you are stuck waiting for everything else to close before you can move on with the house. Now, informal probate, there is more court involvement. You may need to file a specific petition for authority to sell. But even then, the sale happens during probate, not after. The key is having the right legal and estate guidance on your side, which brings me to your options. As the personal representative, you generally have two paths for the property. Option 1, list the home on the MLS. This is typically going to produce the highest sale price. You hire a real estate agent with probate experience, establish market value, and go to the market. A couple of important things here first. You are generally not required to disclose the property's condition the same way a traditional homeowner seller would, because you likely don't have personal knowledge of whatever your parent knew about the property. Make that clear to every buyer. Encourage thorough inspections and due diligence on their part. Second, I want to talk about those unsolicited letters and postcards you're going to start receiving from investors. They always seem to know the moment a property enters probate. Some of these are legitimate, many of them are not. Here's what I've seen happen dozens of times. An investor comes in with a high initial offer to get the property off the market and under contract. Then they inspect and they want a significant price reduction for all the issues they magically found, whether that has the issues or not. Do the full math, not the hopeful math, the real math on the property and what that property is worth. Always require meaningful earnest money. Always get multiple opinions of value before accepting any offer. Option 2, sell directly to a cash buyer. If the home needs significant work and you're managing this from out of state, or if the heirs simply want to resolve this cleanly and move on, a qualified cash buyer can absolutely be the right answer. And I want to be transparent with you. I do purchase homes directly for cash as part of my business. If you're in Utah, you need a fast, fair transaction to settle the estate. That's something I can help you with personally. There's a link below where you can reach out. In 25 plus years of doing this and from going through it personally, here are the 5 most expensive mistakes I see personal representatives make. Coming in at number 1, moving too slowly. The estate owns the home. The estate is paying the mortgage, the insurance, the utilities, the maintenance. Every unnecessary month of delay is money coming out directly of what the heirs will receive. Once you have your letters, move with intention. Number 2, trying to do it without legal support. I've seen people try to navigate this entirely on their own and hit walls they didn't see coming. A probate attorney who knows Utah law is worth every penny. And I'll tell you in just a moment how you can access one at no upfront cost. Number 3, accepting the fair cash offer. Investors are not your enemy, but they are in the business to make a profit. Understand what the property is actually worth before committing to anyone. Number 4, failing to properly secure and insure the property. I have watched estates lose real money because a vacant home was left unsecured or abandoned. Change the locks the day you have the legal authority. Maintain the insurance. Document the condition with photos and with video. You have a legal fiduciary duty. Take it seriously. And number 5, not understanding the tax picture. Here's some good news. Utah has no state estate tax and no state inheritance tax, which is great. That eliminates a significant burden most families in other states have to deal with. But federal considerations may still apply for larger estates, and capital gains implications for heirs can be significant, depending on how and when the property is sold. This is not a small decision. This can have a major impact on what the heirs actually receive. Work with a CPA or a tax advisor. Understand the full picture before you close. So let me be direct about what I can offer you. First, legal support at no upfront cost. I work closely with a probate attorney who will begin working on your behalf from day one with no upfront fee. Their compensation comes from the estate proceeds after everything is settled. So if cost is a barrier right now, it doesn't have to be. Second, a cash offer. If that's what makes sense, if the home needs work, if the timeline matters, if heirs are motivated to resolve this and move on, and just get it sold and be done with it, I can make you a fair cash offer directly. No commissions, no showing, no uncertainty. Third, full representation. If you want to maximize value, I can list the property, manage the probate sale process, and protect you as the personal representative from start to finish. I've done this many times. I know what the pitfalls look like before we even get to them. Whatever your situation, you do not have to figure this out alone. There's a link below where you can book a call with me. It's completely free, absolutely no obligation whatsoever. I'll share everything I've learned, both as a broker through the many years of doing this and as someone who went through this himself in 2020. It can be really stressful and frustrating. And let me know in the comments below, are you currently dealing with a probate or an estate situation? And what's been the hardest part of the process for you? I read every comment and I will point you in the right direction, I promise. Please do me a favor, hit that like and subscribe button if this video has helped you at all, or if you're getting anything out of it, or if you know someone who is navigating this right now, please share it with them. They need this information and most of them have no idea where to find it. It's not talked about a lot. One last reminder, the laws vary by state. Everything in this video is rooted in Utah law and general best practices. Please consult an attorney in your state for guidance specific to your situation. And if you're wondering if now is a good time to sell or if you should wait, watch this video right here. And until next time, please stay safe, my friends.